A very warm welcome to everyone on behalf of Maldives Moot Court Society. We are a non-governmental organization dedicated to advancing the rule of law in Maldives and around the world. And to further our efforts and to raise awareness, we have launched this webinar series, and this is our second webinar. I'm Zahanat Zuhri, the Secretary General of Maldives Moot Court Society and your moderator for this webinar. Before we begin, I would like to quickly remind you to remain muted if you're not speaking. And if you have any questions, we encourage you to type them in the chat box. We'll make sure to attend to your questions toward the end of the webinar. We are grateful for your cooperation and we would like to thank you all for joining us today. Now to begin, I would like to introduce to you all our guest speaker, Mr. Akash Gupta. To give you a brief introduction about our speaker today, he is working as an assistant professor in Jindal Global Law School, where he teaches alternative dispute resolution courses. He also serves as an assistant editor for Indian Review of International Arbitration, and he is also in the peer review board member for Indian Arbitration Law Review and the faculty advisor for Mapping ADR. He has also co-headed the organizing committee for the 24th annual Stetson International Environmental Moot Court Competition and also the Indian National Rounds and 10th Indian Willem C Vis Pre-Moot, organized by Jindal Global Law School. In addition to academia, Mr. Akash Gupta has been appointed as an arbitrator and conciliator in several commercial disputes. He completed his LL.M in International Commercial Arbitration Law from Stockholm University. During the LL.M program, he participated in the Vis Moot and emerged in the top 16 out of the 372 teams from all over the world and received an Honourable Mention for the best memorandum for Claimant. He has graduated from Tamil Nadu National Law University in 2018. During his B.A.LL.B honours, he has also been awarded the Colin J. Wall Spirit of Moot Award at 13th Willem C. West East International Commercial Arbitration Moot in Hong Kong. And out of 1,000 students, he was also awarded the first round Jethmalani Academic Excellence Award 2018 for students under the Moot category. So in this webinar, he'll be giving us a presentation on the basics of arbitration. Mr. Akash Gupta, the floor is yours. Sir, you are muted.
Yes, thank you. I hope you can see the screen now, and thank you so much for this introduction. Okay, so as it is already stated that if you have any questions, please feel free to write on the chat box, or if you want to unmute and ask the questions, you're free to do that. So let's start with a short presentation and then we'll be open for questions. So this presentation is all about the basics of arbitration, what arbitration is, how do you make a career in arbitration, and with respect to certain moots relating to arbitration through which you can learn arbitration. And then we'll be dealing with questions. Now, starting with the first point, like, why do we talk about arbitration? So, if we talk about Indian jurisdiction as such, so there are more than like 5 crore cases pending, which is a lot of cases pending. So the average amount of time which takes for a litigant to finish the proceeding, it is almost around 1,000 days in India, which has been like recently reduced to 600 days. So previously it was 1,200, now it's around 600 days. So there needs to be some alternative to the traditional system of resolving disputes, which is litigation. So now let's understand what is alternative dispute resolution with an example. So let's say that we have, like, you guys live in a law school hostel, and A and B are two friends living in a hostel. They end up into having a dispute. Now, what is the first thing which comes to their mind to resolve the dispute? Is it the first thing that they want to go to the vice chancellor or the dean or the HOD or the authorities of the law school? Or is there some alternative to this? So there are alternatives to this. The first layer is that A and B wants to sit down and start discussing their dispute and try to find a solution for this. Now the second part is where there may be a chance that when they sit down together, they are not able to find a solution. So what they do next is that they ask some of the seniors, some of the juniors, or some common friends or some faculties personally to help them out to find a solution. Now the third stage can be that they are not able to resolve the dispute even through a third party. So what they do, they ask the third party to decide at whether A is right or whether B is right. Now, if we take these examples, the first layer where both the parties sit together and there is no third party and they try to resolve it. So basically that is called negotiation. That is the first layer. Now the second layer is when you invite a third party to assist you in the negotiation, to help you out to find a solution. It's called mediation. Now when you ask a third party to decide which party is right, which party is wrong, when you ask them to adjudicate whether A is right or whether B is right, then you give them a lot of powers. That is called arbitration. Okay, let's say everything fails in between A and B. Even with this, then of course you don't have any other option, then you go to the authorities. That is mostly like litigation. Now, why is that in ADR the most sought after term, the most sought after mechanism is arbitration? There's a reason behind this. So the reason comes from New York Convention and ancestral model law. Now let's talk a bit about what is ancestral. Ancestral is United Nations Commission on International Trade Law. Now this is intergovernmental body, a body, one of the subsidiary body of the United Nations. So in which there are members sitting from almost all the countries, which means all the UN countries. Now their job is to modernize the law on international trade, and also their role is to modernize through a model law. So what they do, they draft a model law, which is more like a dummy law, okay, which you can actually take it in your own jurisdiction. You may copy it, you may edit it, you may modify it. It's up to the countries. So what has happened, there is something called New York Convention, 1958. So that convention says, it provides that, let's say that there is an arbitration award. An award is basically a decision or an outcome, like a judgment from the litigation system. So let's say there is an arbitration happening in Indonesian party, in between an Indonesian party and a Maldives party. So the Maldives party and the Indonesian party has an arbitration happening in India because India is neutral to them. Now India is the seat where arbitration is happening. Now you have an award arising out of the arbitration. Now how do you enforce it? Let's say that you have to enforce the award. The money resides in Maldives. So how do you actually enforce that award? So New York Convention provides that if the country is a party to United Nations, this convention, New York Convention, then you can go to that country and enforce it. So if Indonesia is a party, Maldives is a party, India is a party to New York Convention, you can enforce the award wherever you go. So there are more than 150 countries in which New York Convention has a member, like India, Sri Lanka, almost all the countries which are doing a lot of trade are a party. Only some of the countries are not a part of New York Convention. So that is something which is one of the milestone of ancestral. Now the second milestone is ancestral model law on international commercial arbitration, which is quite like the law, national arbitration law. India is a party to it, Hong Kong is a party to it, Singapore is a party to it. So both of them has actually provided a very good ground for arbitration. So why arbitration is most sought after is because it has a very good enforceability because of New York Convention. Almost like majority of the countries which has followed this ancestral model law, there is more certainty, there is more uniformity in their law. So it's international in nature. You can have arbitration anywhere, and then the idea is that you can enforce it anywhere in the world if it's an NYC country. So that is something called arbitration. Now, some of the features of arbitration is that it's final and binding. So it's not like a court system where you have to go to the lower courts and then there is an appeal to the higher courts, then you go to the constitutional courts, finally goes up to the Supreme Court. So there is nothing like that. An arbitration award is final and binding. The only thing you can do with an arbitration award is you can challenge the award based on the limited grounds provided under the National Arbitration Law. Now, we have to look into this, that why is that arbitration more attractive? One of the reasons why it is attractive is because commercial parties don't want to go to public, because when you go to the court, you go public. All of your details relating to the dispute is in the court domain. And you know that for every case, you can go to the website of the court and you'll get all the data. So they don't want to go public, so they want to go confidential. They don't want anything to go in the public and affect their brand value, their image. So that is one. The other thing is that, let's say you have a commercial dispute which is very technical, relating to, let's say, maritime dispute. And you think that if it goes to the court, there may be a chance that the judge who will be assigned to hear that case will not be somebody who is very good with maritime law. So what you think that if we go to arbitration, we get the right to choose the arbitrator. Okay? So if you get to choose the arbitrator, there is high chance that the person who is appointed by you will solve the case pretty much faster than somebody who solves it from the judiciary. So that is another benefit of having an arbitration. Now, in the arbitration, it is also faster because it has a very tight timelines. So a lot of recent amendments, especially in India, showcases that now the timelines have been provided for each and every step. And a lot of arbitration centers, international arbitration centers, have come up with some new changes in which they provide that for every stage, you have a fixed timeline with an extension time, and after that, you have to either substitute the arbitrator or there'll be a show cause notice against the arbitrator. So all these showcase that how arbitration can be one of the very good alternatives to this traditional system of dispute resolution, which is the court system. Okay, so one of the point which we have to discuss is that in the arbitration system, it does not have any interference with the court. The court's role are provided by the National Arbitration Law. So let's say there is an Indian Act, Arbitration and Conciliation Act 1996. So that act provides what are the places in which the courts can assist, help out the parties to do arbitration. But there is nothing like that the court sits as an appellate body or sits as at the top of the arbitration system. They are there to just help you out with the proceeding. So let's say that one of the parties, there are two parties, like a party from Singapore, a party from Hong Kong, they want to arbitrate in India. And one of the party is not coming for arbitration. So what you do, you go to the Indian courts and you ask them to ask the other party to come and join the proceedings. So that is the role of courts. The role of courts is not to decide a particular dispute. The role of courts are very limited. It is only for supervisory role and it is not for to sit as an appellate body. Now, moving on. Okay, we have some questions, so let me just check it. Okay, so Kempamba has a question that can the seat of arbitration be anywhere? Yes, the seat of arbitration can be anywhere. Now, let's understand what the seat is. So the moment you say that your seat is, let's say, India. So the moment you say the seat is India, it means that the National Arbitration Law of India will be applicable. It's not necessary that you have to fly down to New Delhi and conduct the arbitration. Okay? The seat theory provides that the moment you choose a seat, let's say you say that the seat is New Delhi, it means that the National Arbitration Law in New Delhi will be applicable to your particular dispute. So let's say that there is the other party is not cooperating with you in the arbitration. They are not joining the arbitration. So it's the Indian courts, which are the appropriate courts, where you go and file an application under Section 9 to ask the other parties to join for arbitration. So the seat can be anywhere, But here's the thing: if you let's say that there are two parties, one from Maldives, the other one is from Singapore, and you choose a seat that is Miami, then it's going to be very difficult for you to actually, go to the Miami court and get a, favorable order from the court. Do you get it? So when you choose a seat, you have to make sure that it is easily accessible. The legal system is something with which you are good at. Okay. So usually the seat, yes.
Okay, sure. I wanted to understand more about the seat of arbitration. Okay. Yes, you have told me to say the law that applies would be the seat in that jurisdiction. Let's say the seat of arbitration, like you mentioned, is India. Mm-hmm. So meaning the Indian law or the jurisdiction in which that seat is going to apply. So let's say I'm an arbitrator and I've got less or no knowledge about the seat in or the rules. Is it a UNITRA law or something in India? Okay, something like that. Make me understand. Once one does the arbitration, it's one and the same language that we are going to speak worldwide. Is that what you would advise, or is that what you are saying?
So, can you repeat your question part? Like, what is your question part? Because I got your observations.
Yes. Okay, to make it more clear, if I do arbitration, is it the same language that we're going to speak in Africa? Is it the same language that we're going to use in Asia or these other parts of the world? Are we going to speak one and the same language?
Okay, so Cam, so here's the thing. So the question with respect to language, so this is something which comes at the drafting part itself. So, drafting of ADR clauses is also very important, because if you haven't drafted the arbitration clause in a way which provides a lot of details. So some of the important details are like this: which is the seat, what is the language, which arbitration center gets to, administer the case, how are you going to conduct the hearings, is it going to be online, is it going to be offline, now which is the law applicable to the contract, which is the law applicable to the arbitration agreement, which is the law applicable to the arbitration proceedings. So if the clause is not well drafted, so let's say that you somehow forget to add a clause with respect to language, and let's say you have parties coming in from China, from Russia, and let's say Kenya. Now the problem will be, of course, I'm pretty much sure that English is going to be one of the options, but it's going to be chaotic. Because the Chinese party and the Russian party, there may be an objection that we don't know English. So there may be a chance that we have to hire somebody. So we can't do arbitration in English. So then the problem arises that what you have to do. So for that scenario, there are rules. The arbitration rules provide for this. That the first thing is that the language should be provided in the drafting, in the ADR or the arbitration clause itself. If there is no clause as such, then the arbitrators gets to decide themselves. And of course, what they decide should be reasonable. It shouldn't be like, let's say if I'm the arbitrator appointed in between a Chinese and a Russian party, and I say that I want to do it in English because I know it, then it's not reasonable, right? So they can go and challenge this order. So it's going to be very difficult. It's going to be chaotic. But in some cases, at the end, you have to hire translators because the tribunal says that we decide this language and you have to move forward. Because your end goal is not to, have this in English or in your own language. Your end goal is to resolve the dispute. So it's always better to have a very detailed arbitration clause. So that's why drafting of arbitration clauses is a huge business now. So a lot of big law firms get a lot of money to actually draft a contract, and some of the firms are very good with drafting the arbitration clauses. So the companies, especially the multinational corporations, they spend a lot of money on contract drafting, especially the arbitration clauses, because at the end, the most amount of money you spend is going to be on the dispute resolution. if 1% goes wrong, you have to go for arbitration. So that's why you find like even there are arbitration clauses which are like more than 2-3 pages, because these are so detailed that it almost provides for all the upcoming situations.
Correct. I understand. Thank you.
Thank you. Okay, and coming to the other question, why is commercial arbitration private? Is it because no? So the privacy part comes because these are going to be two commercial entities which have a dispute. So there is one form of arbitration which is called investment arbitration, in which everything goes public, because the parties are a state and a commercial party. So when you have a state involved, so let's say it's the Indian state, let's say Nissan Motors filed a case against the Indian government. Now that is going to be public in nature because there is a state involved, and of course it affects a lot of investors. Okay, so that's why it's going to be public. However, in commercial arbitration, because everything is commercial in nature and there are just two commercial entities participating in the dispute resolution, and therefore everything is confidential because it only affects the two parties. So that's the reason why you have commercial arbitration private.
Okay, great. Okay, got another question. Who can really act as an arbitrator, and how can you get to know this person is an arbitrator? Do you have to only be a fellow of the Chartered Institutes, or maybe just a member, an associate, or any stage? At what stage do you now start practicing arbitration to the full capacity where you can sit parties down and resolve these disputes?
Yeah. Got your question. This is going to be the most frequently asked question, that how do you actually become a mediator, or how do you actually become an arbitrator? So it depends on different jurisdiction, and especially different arbitration rules provide for different standards. But the usual ones are these, that first, like the majority of centers or the jurisdiction requires you to have a LL.B degree, which is the law bachelor's degree. The second is that you need to have some sort of either a training, or if you have been appointed as a mediator or as an arbitrator. So, and also the majority of the countries or the rules also provides, some of them, that you need to have like 5 years of experience or 10 years of experience. But that is something which is changing as we talk now. So the minimum standard is LL.B and some sort of trainings with respect to arbitration or mediation. It can be from any institution. I know that the CIAB is quite famous, or there are some ICC programs which are quite famous, but it doesn't matter which institution through which you have trained. It only matters like if you have like some sort of training in mediation and arbitration. And getting a physical appointments is going to be very tough because you have very senior people in, and there is less likelihood that you get a chance to be in panel. So there is another way of looking at it, because you have like Claros system coming in, online dispute resolution platforms coming in. So it's better to start, to apply to all of these places, physical as well as online platforms. And I'm pretty much sure that things will start work out. So for example, in India, like before 2 years, the minimum experience required was 10 years. Okay, so there was a lot of criticism, and finally the 10 years experience, the minimum 10 years of experience, has been removed from the law. So as of now, like as we talk now, there is no minimum 10 years of experience required. I'm not sure like how it works out in your country. So you have to check if you have an arbitration act, like what is the minimum eligibility provided. So the major eligibility is having an LL.B and some sort of training or some sort of experience. But I'm not saying that you need to have 15 years of experience, because that is something changing.
Okay, correct. Okay, then the other question that I have, I know of 2 or 3.
Can you just type the questions on the chat box, and I'll do some presentation, and then I'll come back to you.
No problem, that's fine. That's fine. Thank you.
Okay, so now let's talk a bit about the forms of arbitration. So there are certain types of arbitration. Let's start with the domestic arbitration. Domestic arbitration is simple. That let's say that you have two parties from your own state. They have a dispute. Two traders, they have a dispute. that is going to be a domestic arbitration. So the dispute, the parties, the subject matter, everything is from the same state. That is called domestic arbitration. Now, if we talk about international arbitration, so if there is an element of international nature, so let's say that there is an international company. So let's say that, you have Sangyong, which is a Korean party, which comes into India to invest, and they, help the highway authorities to build the highways. Now, they have a dispute in India, okay? And let's say the seat is in India. Now, that is going to be an international arbitration. Why? Because there is a foreign party which is attached in this arbitration. Even if, it's happening in India, there is some foreign element attached to it. So that is called an international arbitration. Okay. Now, there are two ways of having arbitration. One is, of course, the ad hoc arbitration, which means that there is no institutional arbitration involved. Ad hoc arbitration is simple, that the parties themselves choose to resolve the dispute without having any interference of a support system of the arbitration center. So let's understand what is the role of the arbitration centers. Just give me a second. So sorry. Okay, so institutional arbitration is where you go to an institution and you say that you have a dispute. Afterwards, you don't have to do anything. For example, you don't have to inform the respondents. You don't have to send reminders. You don't have to fix the venue. You don't have to send them the meeting details, all of this. So you have an institution which takes care of everything. So where does this institution comes from? How do you decide that which is the arbitration institution which is going to administer the case? So let's say it's Mumbai Center for International Arbitration, and that is mentioned in the arbitration clause. Now, the moment you have a dispute, what you need to do, you need to file the case with the MCIA Secretariat. The moment you do it, all the notification goes to the parties, the respondent as well as you. Now, everything with respect to conflict check of the arbitrator, first hearing notice, appointment of arbitrator, or the award publishing, everything comes through this institutional arbitration. So they have a case manager, which is who will be appointed for your case, and they'll be helping you throughout the case with all the details. So that is institutional arbitration. But institutional arbitration is something quite, was not used a lot before, but nowadays institutional arbitration is booming like anything, especially in Asia. So what was there before institutional arbitration? So before institutional arbitration, it was ad hoc arbitration. Now, ad hoc arbitration is simple, that two parties decides to have a dispute resolution through arbitration. Now, they don't go to an institution for that. What they do, they themselves start resolving the disputes. They appoint the arbitrators, they have their own set of rules to be applicable, and they go ahead with the arbitration. So there is no involvement of a third party. Now, what is the difference in between ad hoc and institutional? Why do people choose ad hoc or institutional? So in institutional, you have a great support. Let's say that both the parties are not able to appoint an arbitrator. And if it is ad hoc, how they decide that who should appoint? You have to move to the courts, which will take time. But in an institutional arbitration, you go to the center and the center will help you out. And it's very quick. A lot of arbitration centers appoint arbitrators within 24 hours. So you see how it works. So in all these phases, institutional arbitration is going to be the best option rather than choosing ad hoc arbitration. Now, there is also a new set of arbitration, which is fast track arbitration or the emergency arbitration. Fast track arbitration is when you have a very tight timeline, which is more like 6 months to 12 months, and you have to finish the whole arbitration process within that. Now, emergency arbitration is a recent concept which provides that, and let's say that you want some interim measures, and the arbitral tribunal has not been even formed. So how do you get the interim measures? You have to go to the courts. But emergency arbitration provides that you don't need to go to courts for interim measure. What you do, if you have emergency arbitration within your arbitration clause or the institutional rules, you go for emergency arbitration. Usually, emergency arbitration is from 10 to 20 days, within which you have a decision coming in from the emergency arbitrators. So now that is something which is emergency arbitration. You can read on internet. It's a new thing is like happening all over the world from different arbitration sectors. Okay, so I think we have covered this litigation versus arbitration. So litigation is public process. It's lengthy. There is an appeal system. It's rigid because you have like the civil procedure code or the criminal procedure code or some sort of evidence laws which you have to follow. And of course, it is expensive, but arbitration is also expensive. Don't think that arbitration is going to be cheap. It's just that litigation is going to take a lot of time. So in that way, of course, you can say that the expenses will increase. But arbitration, don't think that arbitration is going to be cheap. Arbitrators charge a lot of money. So in arbitration, it's always confidential. It's faster because it has very tight timelines. There is no chance of having an appeal because these are binding and non-appealable orders. Now, it's flexible because it's the parties who choose the process, the arbitrators, applicable laws, venue, time, and language, everything. And cost, it's going to be costly. It's just that it will take less time. So in that way, you can say that it's cost effective. Now, advantages of arbitration. So so this is something again we have discussed. So let's move to the next point. So building a career in arbitration. So you have different ways of doing it. So you have like online platforms which do a lot of arbitration mediation. So Sama, Court, Resolve 360 are some of the Indian online dispute resolution platform which provides for a case manager roles to the law students. And they also, some of them also pay you a stipend. And also if you are a law graduate, you can join them as a mediator or as an arbitrator. Mumbai Center for International Arbitration is in Mumbai, India. Asian International Arbitration Center is Kuala Lumpur, Malaysia. Singapore, all of you know. So all these three are like very prominent arbitration centers in the South Asian regions, and they provide for internships. So you may, apply and see. Everything goes online, even their internship opportunities. Then you have something called arbitration chambers. So let's say that there is a lawyer who only works in the arbitration field, or there is a retired judge who is now retired and he or she has a very good practice in arbitration. So that is a good starting point if you want to learn through an internship or through some sort of associateship with them. Then of course law firms is something which you already know. Now there are think tanks relating to arbitration. So I would like to add the Kleros Fellowship. So there is a new thing coming in, which is blockchain and arbitration. So Kleros is a pioneer in that. So Kleros Fellowship is also a good idea to join. Then you have, of course, Center for Trade and Investment Law or Vivi Center for Legal Policy, in which you can intern. Then there are some judges who actually deal a lot in arbitration cases. So you can intern with them. That is the judicial internship. There are public sector undertakings, some semi-government institutions which are engaged in a lot of arbitrations. Like, if there is an oil and gas company, they involve in multi-billion arbitrations, you can get a chance to intern with them. Then there is research assistantship with law professors. So let's say that you are interested in some sort of ADR and there is a professor who keeps on writing in that particular area, or they teach that area and you want to tag along in the research part. So you may approach the professors for this. Okay. And how do you start with, making a career in arbitration? So I think the easiest way is like you start looking for the young groups of these arbitration centers, because once you sign up as a young member, one thing is that you'll get a lot of notifications with respect to, the conferences or workshops happening in your own region or even the international region. So then you'll get to know like what's happening in the world with respect to the arbitration field. And there may be a chance that there is a conference happening in your own country, which you can join and you'll see like how it works. The second is that you have to write. You have to start publications or you write some blogs. So there is a very famous blog, which is Fluor Arbitration blog, which is like throughout the globe, it's famous for arbitration blogs. So you may have a look on that and see that if you can start writing, something on, coming in from your own country's specifics that can be published on Fluor Arbitration blog. So Fluor Arbitration blog is also good for the, general update of your understanding relating to arbitration. Now, likewise, you have another website, which is HSF Arbitration Notes, Global Arbitration Review, Thomson Reuters Practical Law Arbitration blog. So these are the places which you should keep in your bookmarks, and you should go every time and read and see, what are the things happening in the world with respect to, arbitration. Now, other way of learning arbitration is that you can start participating in arbitration moot court competitions. So there are, different set of competitions. The biggest arbitration moot in the world is Willem C, International Commercial Arbitration Moot, which happens in Vienna, which happens in Hong Kong. Then you have FDI, Investment Treaty Moot Court Competition. And then you have Taken Moot from Australia. You have a lot of moots now on the arbitration. I'm pretty much sure that there is a very famous one in Malaysia as well. So if you participate through these, then you'll get to know how you actually use all this arbitration knowledge in practice. So it's a good idea to test your knowledge. Now, the last point I'd like to add is network. So irrespective of your age, one should network. And networking is the biggest asset which you can actually get without spending anything. Because nowadays, that you have LinkedIn, and it's very easy for you to connect from somebody in different parts of the world. So just to give you an insight how LinkedIn works, like I got this opportunity to talk to you because of LinkedIn. Do you really think that if we are not connected with some of your members from this MMCS, I wouldn't have got this opportunity to talk to you guys? So this is how it works. Like LinkedIn is like quite open to everyone. So please feel free to make an account, update it, engage in conversations, try to write something on LinkedIn, and you have to attract some sort of traffic, and that will come to you when you are active. It's not just that you make connections and then you are lost on LinkedIn. You don't write anything, or you are not engaging in any sort of conversation. So that is something which you have to do to network. And thank you. That is from my side, and now I'm open to questions.
Thank you very much, Mr. Akash Gupta. We are truly grateful for the time you've taken to join us and enlighten us. So yes, before we let Mr. Akash Gupta go, if anybody have questions, they are free to unmute themselves and ask questions. There seems to be already a few questions in the chat box. I will read them one by one so that you could attend to them. So first question is, can a civil engineer do and practice arbitration? Is arbitration clear in the construction industry?
Okay, so here's the thing. An arbitrator is not required to have LL.B degree in all the cases. So let's say that if you're a civil engineer and you have very good amount of experience, or let's say you're a doctor, or let's say you are, what else? Some sort of blockchain expert. So if or let's say you are very good in the maritime industry, like you have worked on ships and you know how it works. So any industry, you have a good experience, so you can be very good for arbitration. Let me give you an example. So let's say if it's oil and gas dispute, multi-billion project, multi-billion dispute in between, some Russian party and Indian party. Now, if somebody has to appoint an arbitrator, of course, there are two things. One is somebody who can, take the arbitration. For example, all the process, that it should be fair, it should be, fast enough, for which you need one of the arbitrators to be very good with law. Now, the second one, you may require somebody from the industry itself. So if, let's say, somebody has done, petroleum engineering, and they have like 5 years of experience, that person is also going to be a very good asset on the tribunal. So there may be a chance that if you are a good industry expert, that you'll get an appointment. So a lot of arbitration centers, a lot of jurisdictions, they say that if you don't have a law degree, but let's say you are a professional, let's say you are a civil engineer and you have a good amount of experience, you're also eligible to become an arbitrator. But for that, the the bigger question is that unless until those persons are impaneled on an arbitration impanelment, let's say that there is XYZ arbitration center and they don't have anyone impaneled from the civil engineering side, then how are they going to appoint it? Because a lot of people in these industries are unaware of arbitration. Even if they're aware, they feel that it's going to be very difficult for them to get the impanelment. And this construction industry is a huge industry for arbitration. Let me tell you about this. So I interned in my final year of law at the Asian International Arbitration Center in Kuala Lumpur. And in Kuala Lumpur, I got to know that there is a particular law on this construction adjudication. So there we have a law which provides that the moment you have a construction dispute, you have to go to the arbitration center to appoint an adjudicator. So instead of calling it as an arbitration, they call it adjudication. And they say that the moment you have a dispute, the administering body is going to be Asian International Arbitration Center. So the moment you have a dispute, all you have to do is send a notification to the center, and the center appoints somebody from the panel. And after that, what we have seen that there was a tremendous growth in the adjudication cases. So at some point of time, the adjudication cases went beyond the arbitration cases. Because you know that in construction industry, a lot of disputes are there. It's just that you don't know how to resolve it. So for example, if you talk about what's the scenario in India, there is nothing like, an institution which is designated for construction adjudication, like Malaysia. So there are different ways through which people are actually resolving it. But think about this, having one designated center, it's going to change the game in the construction adjudication. So yes, a civil engineer can, if they have a good amount of experience, depends on your country or, the arbitration center in which you want to impact.
So let's see, there's a second question as well. It says that including fast arbitration and emergency arbitration, how many kinds of arbitration are around? And what is the most ideal kind of arbitration for cost time efficiency?
Okay, so if you ask me what are the different types of arbitration, there is one commercial arbitration. That is something which we have discussed. Now there is something called investment arbitration, in which you have a commercial party against the state. Now there is another kind of arbitration which is state versus state arbitration. So if you may have heard about a very famous arbitration coming in from Africa where there were two state boundary disputes. Or let's talk about this, India-Pakistan, the run of Kutch arbitration. So there was a border dispute which was resolved through arbitration. It looks really, it doesn't look that it has happened, that India and Pakistan has resolved it, but this is something which has happened and it still holds the law. Both the parties are actually, following this. So there are these three sets of arbitration. Now coming to the methods, how the process, how there are different arbitrations things. So one is of course the usual arbitration process. The other one is the fast track, which is more like 6 months, and then you have emergency, which is more like 10 to 15 or 20 days. So these are the different sets of arbitration.
Okay, we have another question as well. It says that where does arbitration and litigation merge?
Okay, so I'll say that there is no merging point for litigation and arbitration. It's just that if, let's say, one of the parties in arbitration is not following the orders of the arbitral tribunal, you may go to the courts and file a case against them. But you can't say that it's merging. All you can say is that you are going through the litigation to get it enforced. So there is no question that arbitration and litigation are going to merge. It's just that, let's say, if one of the parties is not complying with, you go to the courts and make the other parties comply with that order. So I will say that arbitration operates in a very different system and litigation operates in a very different system. It's just that the arbitration system gets the support from the court system.
Okay, thank you. We have another question as well. What are the circumstances in which the arbitration ruling can be appealed?
Okay, so one of the things is that an arbitration award cannot be appealed. It can only be challenged. Now, let me simplify this for you. Why do I say that it should be challenged, it shouldn't be appealed? Because when you say appeal, let's say that the lower courts of Maldives decides that, party A has to pay party B rupees 1 million for the breach of contract. Now, when you go in appeal, the higher courts may say that no, party A does not have to pay. It's actually party B who has to pay. Now, let's say it goes up to the Supreme Court of Maldives, and then there may be a chance that they decide that party A has to pay or party B has to pay. Now, in arbitration, what happens? Let's say that the arbitral tribunal pass an award which provides that party A has to pay party B rupees 1 million. Now, in that case, when you challenge that particular award, the courts which are hearing the challenge, they have two options. Either they say that we agree with this and party A has to pay, or they say that we annul the award. Annul the award means that the challenge is successful. Now that award does not have the force of law. So it is more like, let's understand this with a French example. Assume that when the award is more like a guest coming to your house, okay? And the guest is wearing hat, they have an umbrella in the hand, and they move into your house, they knock the door. Now, when you open the door, that is a jurisdiction. The house is a jurisdiction, and the guest is more like an award. So the only thing which you say to the guest is either you come in, or you say that no, please don't come in. You don't say that you have to remove your hat, you have to, throw your umbrella. So the idea is that you can't change it. Either you take it as it is, or you say that we reject this. So that is challenge. Now, there are certain grounds for challenging it. There are limited grounds. One of the grounds is more like when the arbitrators are biased. They are not independent, impartial. Let's say that the arbitration clause is with the dispute is with something relating to, marriage. And marriage is not arbitrated in majority of the countries. So can you arbitrate marriage disputes? Or let's say there is a criminal dispute. There is a murder or rape dispute. Can you actually arbitrate this? Let's say even if you arbitrate, will the courts enforce this? The answer is no, because the courts will say that this is against our public policy. So there are limited grounds of challenge which will be used. That's the reason why you can't appeal any arbitral award. So in appeal, you have more room. You can change. So it also deals with the substantive parts where you can change the amount. You can do whatever you want, like the courts. But in challenge, there are only limited grounds through which you can actually annul the award and say that this award is not valid under the law. So basically, when you annul the award, it means that the award does not have any force of law in that particular state.
Okay, one last question. Why litigators hate and feel unsecure towards the concept of arbitration? Don't you think it decreases the opportunities for young litigators to earn who are dealing with not rich parties in average legal matters at daily routine?
I'm not sure that if the litigators hate the arbitration system, because especially if we talk about the South Asian countries, we don't have a different pool of litigators and different pool of arbitrators. So if we talk about US, so in US, there are two different pools. One is the litigating lawyers. Second is the ADR lawyers. So the ADR lawyers don't do litigation. So they only deal with mediations, all the mediations like commercial mediations, marriage mediations, property mediations, all of this. But if you talk about South Asia region, you don't see per se that there are two pools. The litigators, the people who actually goes to court, they practice in the courts, they are the ones who actually do all these ADR things. They do the arbitration, they serve as a counsel in the arbitration, they also serve as a mediator in all those disputes. So the first thing is that they don't hate because they are themselves a part of this. There are no two pools to this. That's first. And now, coming to your second part of the question, don't you think it decreased the opportunities for young litigators to earn who are dealing with not rich parties in average legal matters at daily routine? I'll say that no, it will not decrease, because at the end, the world is moving towards alternative dispute resolution. So because, of course, like there are backlog of cases, there are more, stringent laws, or there are more procedures involved in the litigation. So the parties are moving towards arbitration or ADR. So, going by this PwC recent report, Indian companies, 95% of them have an arbitration clause. If you go on Google and you start searching how the financial corporations are actually resolving disputes, you'll see that a lot of financial corporations in India are using online platforms now. So the idea is that when you use these platforms, the online platforms, or when you choose ADR, it actually gives the youngsters a lot of room to actually join this and find good jobs. It's not exactly that you lose out jobs, it's actually that you are creating jobs for the youngsters. Think about this. Do you really think that somebody who has 15 years of experience wants to change their practice style and move to the online dispute resolution platforms? The answer is no. But think about this. Let's say that you're a fresh graduate from the law school and you find a job opportunity with one of the ODR platforms. That is going to be very easy for you because you are good with technology and you are eager to learn something new. But somebody who is already has a very good experience, for them it's going to be very difficult, change their practice style. So I will say that it's actually the other way around. And the young litigators have a greater chance to be hired in this, new techniques of arbitration. Yeah.
Okay, once again, thank you very much, Mr. Akash. With that, we have reached the end of our webinar. Thank you all for joining, and we hope to see you all in our next webinar. We will let you know the date and any more details of the next webinar in the coming month. So follow us on our social media handles and check out our website, which you can find in the links in the chat box. Again, thank you very much. Good day to everybody. Thank you, Mr. Akash.
Thank you. Bye-bye.